I want to talk a little bit about first an introduction to what mediation is, kind of some of the basics of mediation, and then talk to you about why I feel it's really effective in high conflict family law cases. Okay, so what is mediation? Mediation is a process where an unbiased third-party neutral helps parties come to an agreement. So a neutral is someone who is not in any way connected to the litigation or the case, and works with the parties through the process of mediation to try and help them come to a compromise. Usually people walk away from mediation happy with a lot of it, and maybe a few things they're unhappy with, but at least it's their own choice. They decide whether or not they are happy with the mediated outcome and whether or not they're going to accept it. There's no judge. The mediator can't force you to do anything. And so it's your own decision. You get to decide whether or not the compromise is acceptable to you. And it's not a decision of a judge that basically hears the evidence and says, this is the decision, whether you like it or not. And I think, you know, having that amount of control and that amount of input into the process, people walk away from mediation, I think, much more happy than they do most of the time in trial. In Washington State, almost all the counties require mediation or alternative dispute resolution, which is ADR, some form of it before going to trial. In most family law cases, certainly King County and Snohomish County do, and Pierce County does too. The only exception is if there are cases with domestic violence where there's, you know, that sort of dynamic, courts will waive the requirement for mediation. And parties can mediate almost all types of family law cases, whether it's a parentage case where you're trying to figure out who the parent is and how child support is going to be set up, a parenting plan, whether it's a dissolution, you're trying to figure out how to allocate assets, again, a parenting plan, child support, all the aspects of family law cases, child support cases, all those cases can be mediated. And I actually recommend that most parties try mediation in their cases. So some of the details and the basics of mediation. Most of the time I find that a full day mediation is more effective. It allows the parties to think about things, to come up with solutions, to work with the mediator on the details. If you've got a fairly straightforward case and there are just a couple of issues that the parties disagree on, then a half-day mediation, 4 hours might work. But for more complex cases, at least 8 hours is what, you know, is usual. And sometimes, you know, you come back if the parties really want to try and come to a solution, but they aren't able to do it in 8 hours. Usually the cost of mediation is split between the parties, 50-50. That way both parties have an equal stake in the process. And that's usually the way they're paid for, and usually what I recommend just because of that. So both parties are coming in with an equal stake and with a commitment, an equal commitment to the process. A question of when to mediate. Some parties like to mediate early. They don't want to keep going for months with their case. They want to settle it. They think that they're going to get there. So for those types of parties, you know, an early mediation may be a good option. Most mediations that are done closer to trial, where there's more of a fear of trial, a lot of times they'll settle more in that case. Another question for mediation is whether or not you want to do it with an attorney. It is possible to do mediations without attorneys, and there are mediators who do those type of non-attorney mediations with just the parties there. And for some people that can work. I tend to recommend attorneys because, number one, if I'm your attorney, I can protect your interests in a mediation. I can, tell you what types of things, are in your best interest or not in your best interest. A lot of times I don't say a whole lot in a mediation if I'm your attorney, but I'm there with you. You can ask me questions. I can, give you my take on what the proposals are. And then the mediator is basically talking to the parties. And if the other party is represented, then the other party's attorney is doing the same thing. The other reason I think that it's good to have attorneys in mediations is that we can help prepare the mediation materials so that they're clear to the mediator, so the mediator has all the financials they may need, for example, and we can get to know you and figure out what it is that is really important to you, what are the most important things that you want to have come out of this mediation, and we can present that to the mediator in the mediation brief that basically tells the mediator what the issues are, what the most important things to you are, and make sure you have the backup materials and evidence that you need so that the mediator knows what they're dealing with going in. Another thing about mediation is that it's totally confidential. Nothing that's done in mediation can be used in trial. There's actually a rule in Washington, Evidence Rule 408, that says that nothing that is said or presented or done in mediation can be used in trial, and that it's all confidential. And that's a really nice thing because you can get creative and you can say things in mediation that the other party, can't use in trial. And so you might be able to, bend a little bit more than if it wasn't all confidential. And finally, what your goal is going into mediation is to come out of mediation with a settlement agreement. And one of the things that mediators stress, and that I would stress as your attorney, is that it needs to be done before you leave the room. A lot of times people, if they leave the room and then come back and try and do it, then there's buyer's remorse, or there's, no, I don't want to do this after all, that sort of thing. And so, you need to be sure that you're ready to sign the settlement agreement. It needs to be something you're ready to do. But sometimes, attorneys have been known to go to 2 o'clock in the morning in mediations just because it's so much better to get the settlement agreement signed before the parties leave. And once you have that settlement agreement, then you draw up the rest of the documents that the court needs to go with that. And it may or may not, generally it's not filed with the court, but sometimes it is, it's often filed with the court, depending on what type of case it is and what information the court may need. So I entitled this this presentation, Mediation in High Conflict Family Law Cases. And you can mediate low conflict family law cases. As I said, sometimes you might need, only 4 hours. And sometimes people might think, well, there's no way I can mediate this high conflict case when there's so much emotional stuff going on between me and the other party. There's just no way I could deal with them. I could do anything like that. We should just go to trial. And I think that high conflict family law cases actually, I think that you should mediate high conflict family law cases. And here are my reasons why. These are very often emotional cases, very, very emotional cases with children involved. And if you go to trial, everything that is said in trial is in the public record. Everything that's presented in trial is in the public record, whether if there's substance abuse issues, there's allegations of child abuse or domestic violence, all those things are in the public record. And someday, your children may go back to that public record and look at it, but it's all out there. And I do think the confidentiality in mediation really serves the future. It serves the future for you, for your children, for your family. And trials can be very, very bitter, and everything that you think could discredit the other party, that could help you make your case. I mean, that's what attorneys that go to trial, that's what they have to do, to present the best side of your case. And certainly, you know, I have done trials, and all attorneys, well, not all attorneys, but most family law attorneys have done trials and can do trials. And you know, if that's what we need to do, your attorneys need to do to present your case and get you the best outcome you want, then that's what we do. But I also think that high conflict cases, there are special dangers in going to trial. And nothing for mediation is allowed in court in trial. And if you fail a mediation, you can go to trial. But nothing that was done or said in the mediation is admissible in trial. The other thing I think in high conflict family law cases, I often like to use mediators who are former judges or former commissioners who have a lot of experience in the family law court and training in mediation, and who know, for example, the other judges and the commissioners who you might be going to trial in front of if your mediation fails. And they're able to say, you know, if this came before me as a commissioner, or this came before me as a judge, here's how I would view it. Here's how I would probably rule on this. And so they're able to give you a reality check of whether or not what you're asking for, or whether or not the other party is asking for, is reasonable, is something that they're likely to get. And I think when you have that expertise, you have someone who can pull you back to what is possible. And the sooner you can do that in mediation, the sooner you can jettison, you know, I want all of this, and you know, my partner have none of this, the other party to have none of this. The sooner you can get down to what is likely and possible and what a court would rule if you went to trial, the better. And the really seasoned mediators, and in high conflict cases, again, I like to use former judges and commissioners, although there are a lot of other mediators out there that, you know, do an excellent job. And I also like to use mediators that are really good at conflict resolution. And again, the expense of mediation versus the expense of trial is a huge, huge incentive. Trial can cost anywhere from $25,000 to $100,000, depending on what has to be done in your trial. What kind of evidence has to be gathered, what has to be presented, how long it's going to take, how long your attorney has to prepare. Mediation, probably $5,000 to $10,000 at the most. Although I hate to say at the most, because I never know. But you know, you pay your attorney fees, you pay the mediation fees, and that's probably the basics for mediation. It's much, much less expensive. And the other thing about mediation is you can be really creative. If you go to trial and you present creative solutions to a judge, then the judge might consider them. But in mediation, you can work together with the other party. So, you know, if you want a creative parenting time schedule, one of you works nights, one of you works days, or one of you is long distance, you can work out something creative that works for the parties instead of a kind of one size fits all that a court might impose on you. If you want a division of the assets that's creative, you can work on that with the other party. And I think that the creativity that's possible in mediation is a real plus, because it helps so that parties are more likely to walk away happier with the outcome. The other thing about mediation is they don't have to see each other. Most mediations right now are being done via Zoom. And that was the case, you know, during COVID pandemic, and may still be the case depending on what happens with that. But when you go into mediation, one party and their attorneys put in one room, and the other party and their attorneys put in another Zoom room, and the mediator goes back and forth. And so, yes, you sit there for a while, and your attorney sits there for a while, while the mediator is with the other party, but you don't have to see the other party. You don't have to hear their opinions. You don't have to hear anything about them. And then the mediator will come back and say, okay, here's what the other party said. Here's the other party's reaction to what you proposed. And the mediator goes back and forth, so you never have to deal with each other directly. And that isn't, I mean, that is a choice too. So if you want to be in the same room and you feel like it would work more to your advantage to be working with the other party, you know, in the same room with you, that's your choice. But in high conflict cases, a lot of times people choose to be in separate rooms and not to see each other and not to deal with each other. Whereas in trial, you know, you're sitting right there and you see each other and you hear the things that the other person says about you and about the issues in the case, and it can be very, very, very unpleasant. And finally, I think that when you're considering trial versus mediation, I think it's important to consider the end game for your life. What do you want your future to be? If you are parents with the other party, you have to parent your children together until they're 18 years old and possibly longer if they go to college and they are still dependent. And are you going to be able to co-parent with this person if you go to trial and you hear all these awful things that you say about each other? And what effect is that going to have on your kids? If you go to mediation, you work out a compromise, you know, the bitterness, the rage, the pain, sometimes the hate that, you know, is there at the time of your dissolution, or if you're going, you know, the legal route on child support or parenting plan. But in the high conflict cases, I really think you need to think about the fact that, you know, maybe you need to deal with this person as the other parent for the rest of your life. Or maybe you want to walk away from this. You don't have kids together, but you want to walk away from this and not be filled with rage and bitterness, not having had, you know, something imposed on you by a judge, having reached a compromise, and then walk away and start your life over and get on with your life in a more positive way. And so I think that mediation is a really, really good choice if you're trying to look for an end game that might let you have a more positive outcome and not be caught up in all the emotional stuff that comes along with you know, those difficult times in your life where you have to be in the legal system. So in May, I'm going to host a second webinar, which is going to be 3 mediators with different philosophies and you know, backgrounds and that sort of thing. And I'm just going to ask them some questions about their philosophies, their experiences, what types of some of their case law cases that they've had, how they deal with high conflict cases, that sort of thing. And I'm just going to let them tell you some of the basics of mediation with each of them. And I think it should be really interesting. And it gives you more of an idea from the horse's mouth, not just the attorney, but the actual mediator, how mediation works. And, you know, maybe you can think about whether it might be something that would be right for you. So if you have any questions, my name again is Susan O'Toole, and that's my email there, susano@beresfordlaw.com, and phone number 425-776-4100. And I'm happy to speak with you if you have any questions, and have a great day. And I will be here next month with some mediators. Take care. Bye-bye.